Dean. Mr. Kirchhoff represents Mr. Dean. This is a motion filed by the plaintiff mother regarding custody. The judgment of divorce gave joint legal and physical custody to them. The complaint basically now is from Mr. Dean that she changed the kid's schooling to Eaton Rapids without a Lombardo hearing, but she wants to change custody. Mr. Worth, what do you have to say?
Yeah, Your Honor, my client prepared and filed the motion at issue on her own. I think in reviewing what her intentions were with the motion, I think it would be twofold. One, to schedule an evidentiary hearing with respect to the issue of custody. Her allegations as to change of circumstance or proper cause threshold essentially relate to, from her perspective, a change of custodial environment in that she's exercising the vast majority of the parenting time, as well as concerns and frustrations that the children have raised with respect to their preference and where their living environment is. The second piece of that is a Lombardo hearing. When I spoke with Ms. Dean, she was not familiar with what that concept was in Michigan law, but acknowledges that a Lombardo hearing would be the appropriate type of evidentiary hearing to have in this matter with respect to the change in school district to Eaton. In reviewing Mr. Kirchhoff's response and in his prayer for relief, it appears that he agrees with us that we should have an evidentiary hearing. Not that he agrees with what the outcome and the issues might be, but I did notice that he requested that this be set for an evidentiary hearing. We agree with that this should be set for an evidentiary hearing so we can present evidence and witnesses with respect to proper cause for a change in custody, as well as with respect to the school district under Lombardo. So to keep it somewhat short and sweet for purposes of this morning's hearing, we would request that the court schedule an evidentiary hearing as to proper cause and best interest for a change in custody, as well as for a Lombardo hearing.
Clearly, the court has to schedule a Lombardo hearing, and clearly she has no right to have changed the kids' schools, and the kids have to be returned to their prior schools. She does not, and she has been through this before. I think we did schedule something before, wasn't it scheduled before, Mr. Kirchhoff?
Yes, it was.
She knows that she can't change the schools unilaterally. They have joint legal custody and the children will be returned to their prior school starting Monday. As far as anything else, Mr. Kirchhoff, what have you got?
Yes, Your Honor, there's a couple of things. Number one, she's talking about having the vast majority of time with her children. She unilaterally moved to Eaton Rapids, took the kids with them, and won't let Mr. Dean see them. It's that simple. That's a real easy way of getting the vast majority of time, I guess. It is absolute lie that she does not know that she has to go through some kind of a hearing, because we did this 2 years ago. And when the court set up an evidentiary hearing, she withdrew her request. And again, she tried to change the school 2 years ago with an ex parte order that was denied, said that she changed them and didn't even bother putting them in school at all. And they missed about a month of school last time. She knows exactly what's going on and she's lying about it. In that regard, what we would like to have is have the children return to Mr. Dean tonight after they get out of school, if she's even put them in school, because he's getting notices that they're not showing up to school. At any rate, then during the period of time, just like last time, while this is pending, Mr. Dean should have the children Monday through Friday so he can get them to school, and then she can have the weekends, just like last time, pending the appeal. Now, the other thing that we're asking for is she knows exactly what's going on. This is an absolutely flagrant violation of the order. She knows that she's not allowed to do it. She's going to do it anyway. I'm asking that she be held in contempt. I guess I'd like to see her spend maybe 7 days in jail.
Well, that's going nowhere at this point. This is an initial hearing and I'm not locking her up for it. I will do whatever I think is appropriate for the children at this time. Mr. Worth is correct. We do need to have a Lombardo hearing at this time for this. I don't know if Miss Dean is going to just simply live in Eaton Rapids, and is she going to get the kids on the appropriate time to school? The kids will be returned to school because she knows that that was up. Mr. Worth, if she told you she didn't know anything about it, she is not truthful with you, because we did have this exact issue a couple of years ago. And I did schedule a hearing, and she knew that it was there, okay? So the kids will be enrolled in the Grand Rapids school that they were in. I think it's City High or something like that. I don't remember exactly what it is. A good school. They'll be there on Monday. I don't know how to, like I say, I'm not sure with Miss Dean, if the regular parenting time can go on, that's fine. If not, then the kids have to stay with Mr. Dean during the week because they're gonna go to school here. And I don't, if she's staying in Eaton Rapids, she can't get them here. I don't think she can get them here in the morning and get them home at, get them afterwards. As far as her request for proper cause or change of circumstance, basically, I don't see it at this point, because one of the things that she's saying, oh, the kids, want this, Mr. Worth, that is not something that the court can use as a reason to find proper cause or change of circumstance. The fact that she has moved away and he doesn't get as much time, I don't see any proper cause. If you want to add something else that's verifiable, fine, but other than that, I don't believe we have a custody fight that is appropriate for me to have a hearing on custody. I will have the hearing on schools. I don't, that's dictated by the law, and I'll be having that, and we'll schedule that. I don't know, it probably won't be until January, but we'll see what we can do on that. Mr. Worth?
I was just going to say, thank you, Your Honor. The only addition to the allegation that she's blocking the parenting time, it's not a matter of blocking the parenting time. She is relying upon a prior order when she lived in the Lansing area, in which they were to meet at a halfway point. She thought that because she was back in the Lansing area, that shared transportation provision would be back in place. Unless the court has a different view on that, it possibly is a moot point, since it sounds like Miss Dean's going to need to be back in the Grand Rapids area for the children to attend school, and transitions can happen in and around the school schedule.
Like I say, if she's telling me, and you can go into a breakout room, we'll send everybody off, and I'll take another one for a minute. If she's saying that she's going to be able to provide the transportation to these kids in the Grand Rapids School District as from prior orders, I'm not going to change anything and at this point, all right? But if she's not, then he's got to have the kids from Sunday night through till she can pick them up at school after school on Friday.
I understand exactly the court's position on this. I think Mr. Kirchhoff and I can speak offline about what the reality and practicality of that's going to look like.
Mr. Kirchhoff, I think that's appropriate.
Well, what I would like to do, Your Honor, is have an order that is identical effectively to the November 16th, 2022 order entered by this court, saying the children shall remain enrolled in Grand Rapids Public Schools, and then have until the plaintiff actually moves back to Grand Rapids. The defendant shall have the children from Sunday at 7 until they are in school on Friday morning, and the plaintiff shall pick them up from school Friday night until Sunday at 7. We don't trust her.
And that's
absolutely
Mr. Kirchhoff,
not.
Stop for a minute. I understand. That's what I basically said is going to happen. But Mr. Worth, if she in fact is back in town, then the only thing I need is that. She apparently has moved, and that will be the order. But you and Mr. Worth, I don't think Mr. Worth understands from his client, at least. If she's there, if she's in Eaton Rapids, that will be the order of the court. If not, if she's coming back, then we'll deal with it at the evidentiary hearing. Mr. Worth, give Mr. Kirchhoff a call soon. Mr. Kirchhoff, you'll be there?
I will be here this morning.
All right. that is the order that I'm ordering unless
Okay.
she is moving back, all right?
Then I will draft, again, I'll draft the order for submission, Your Honor.
And the kids are to be enrolled in the Grand Rapids schools Monday. All right, good luck, everybody. We'll set up an evidentiary hearing if that's necessary. I'm assuming we need a Lombardo, so I will set that up. Good luck,
Thank you, Your
everybody.
Honor.
Thank you.
Thank you.
Thank you.
Cruz versus Thompson. Ms. Thompson has simply made a motion. The friend of the court got this case, was referred to the friend of the court a long time ago for child support. They sent out a recommended amount as of 2/27/24. There were no objections to that amount at all, and she's just asking that order be entered. Correct, ma'am?
Yes.
Sir, what's your response?
My response, to me, it don't make no sense because we already have joint custody. I'm doing my part, which is half and half. I'm taking him every day that I'm supposed to take him, plus, because the day that I don't supposed to have him, the day that she's supposed to have him, she's supposed to take him to soccer practice, and she's sleeping all day. So I have to go pick him up from her house. Or my mom have to go pick him up from her house to take him to soccer practice, to take him anywhere, cause she always sleeping. I'm doing my part. So that right now don't make no sense because joint custody, you take care of him in your house, I take care of him in my house.
Who
And I'm
pays for
doing my
child
part.
care? Ma'am, did you verify child care?
Yeah. I did. I put down that it was my daughter. She's 19. So, as far as the joint custody is only for him for Sunday to Wednesday. So,
Well, he's been given 178 overnights. It's close to joint custody and
yeah,
that's been in there. Are you saying you pay your daughter to watch your child?
yeah. I work third shift.
You see, but I'm sorry, excuse me. That's not my responsibility because the day that I got him, I gotta pay child support. I gotta pay child care. I gotta figure out my way to take care of him when he's with me. I work. So I gotta figure that out just the same way she gotta figure that out when he's with her. It's the same thing. It's half and half. I gotta figure it out. She gotta figure it out. Because when I got him, I worked second shift. So I gotta figure it out who gonna pick him up from school, who gonna watch him while I'm at work. So it's the same thing. She's not making no sense.
What is in the calculations in the friend of the court report that's incorrect?
I don't get it.
Well, I mean, I'm not saying you don't get it. I'm saying the income, the amount, the premium payments, what? I mean, what is it that is in here that is incorrect as far as their calculations?
That I don't get what I have to pay child support if we got half and half. She take care of him at her house. I take care of him at my house. I don't get it why I gotta pay child support.
There are many people who have 50-50 who have to pay child support because of the disparity in income and things like that.
She make more money than I do. I gotta pay everything on my own.
It doesn't show in here that she makes more money than you do.
I don't even work no more than 2, maybe 3 days because of my health. So that's not
Then-
even accurate.
But then if that's the case, then you aren't paying that much in childcare.
Yeah. Because my disease, it fluctuates. So sometimes I do have to work.
Well,
And
but you don't pay as much in, I'm gonna refer this to the friend of the court once more. We're gonna send it there for their determination. Both of you better cooperate with the friend of the court. They're gonna make a recommendation. I'm gonna enter that order unless there are objections to it, and then I'll have a quick hearing on it.
Sir, I got another thing that is bugging me. I think my son is better off with me because she
That's
works
not up for today. No motion has been filed. You have to give notice. You can't just come in and start talking about stuff. This is a child support motion. I'm sending it to the friend of the court for their review. Thank you.
Thank you.
We're here in the matter of Furtado versus Furtado. 22-7287 DC. Both parties are present via Zoom. I was notified by my clerk that Mr. Furtado said he didn't know about this motion until I think he was contacted by the court regarding it proceeding. Sir, what do you have to say about this?
Your Honor, I was not properly served, but I knew there would be some type of meeting with the court. That's all. I don't know what this is about. I don't know what's written in the papers.
You
I
never
haven't-
got the papers, you're saying?
No,
Ma'am, when did you send them to him?
I sent them on October 17th at 10:59 a.m.
What do
About
you mean?
17 minutes after I filed them with the clerk.
How do you get, I mean, how did you send them to him?
I sent them first class mail from the United States Postal Service.
To the address, to his address?
Correct, that I had from friend of the court.
So it was sent October 17. That's well over 2 weeks ago.
Correct.
That's proper service.
I haven't received it.
Well, I mean,
I requested a copy with the FOC and with the judge's clerk, but I wasn't able to get a copy on my email, and I haven't received anything in my mailbox. I know this is a recurrent issue because sometimes I send documents and they don't get there or get there like months later. Unfortunately, I live in a different country.
I know. All right, this is, I think there is proper service. However, this is not really a time sensitive motion, quite frankly. It's a motion for what you're gonna pay for portions of travel for the kids. When's the next travel time for the kids going to be?
June, Your Honor.
Yeah. All right, and I mean, she's asking for reimbursement for attorney's fees and differences in costs and this kind of stuff. I don't see anything in here that is so time sensitive. Ma'am, is there anything that has to be ruled on today that's going to affect things?
Sir, he has only given me $121 since May for child support.
That's up to the friend of the court to enforce that.
They are not able to enforce it.
Well, so what do you want me to do?
I mean, some of it comes to how this agreement is.
Yes, and that's what I'm saying.
Right?
It's not time sensitive, and quite frankly, can you email him your motion, ma'am? I'm just gonna put it off for 2 weeks,
Okay.
and we'll hear it in 2 weeks. I'm not sure, do we have his email address? We don't have your email address, sir. And I don't want you to say it right now because we're on YouTube. You got my
I
clerk.
put the FOC on my email. I'm sorry to interrupt. I didn't mean to.
No, I'm just saying, you called my clerk. Oh,
Yes, and I contacted
you
them by
emailed my clerk. Email my clerk your address. And ma'am, I would like you to email it to him, but if nothing else, rare though it may be, we'll probably send him an email of your motion, so there won't be any question that he gets it. Can you email it to him? Do you have his email address, ma'am?
Yes, I can email it to him.
Is it a problem to email it to him?
No, not at all.
Can you do it sometime today?
Yes.
Sir, she's gonna email it to you. And you're gonna be here 2 weeks from now, and we are gonna hear the motion 2 weeks from now, okay? I'm giving you a break this time, all right? Because you do live in Brazil, and I have no idea what the mail is like there, but she did what she needed to and was appropriate for notice for this hearing. If this would have been something that was time sensitive, we'd proceed with it right now. All right?
Yes,
And
Your Honor.
I'm gonna tell you, up front, one of the things she says is that you guys had actually agreed on 50-50 for the amount of costs for the kids. It does appear in the emails that she sends to me that you did agree to it, so you're gonna have to figure out how it is that MCR 2.507 parens G does not apply. Which is, if two parties agree on something in writing, they agree on it. And it does appear that you agreed on it from what I could see in there. I'm just giving you a warning up front. All right? To both of you, basically. All right?
Yes, Your Honor.
We'll get you that information. We will have it scheduled for 2 weeks from now.
Okay.
All right?
Thank you.
Good luck, everybody. Thank you.
Good morning, Judge.
Good morning. Looking to see if you have your client there.
Yes. I should point out to the court, I did discuss this case with the plaintiff and told her that she wanted to swear under oath that she had no income.
That's what my intent is after reading her response.
Yep, she swear that she has no income. You don't have to have the motion. To the court, I did discuss this
Hold on. We don't even have Mr. Hornus in here yet, okay? Hold on.
Turn your volume.
Can you hear me?
Yeah, we're working on volume.
Mr. Volume. So yes, you can hear.
Yes, yes.
We object to him being involved.
Yeah, you get off the screen. You're not part of the case and you're not an attorney.
Oh, okay.
Am I allowed to have someone with me?
Well, I'm sure somebody's in the house with you, but you're not, no, not as a representative or anything.
That's fine. I'm sorry.
And if you're here, you'd be sitting up at the table by yourself. Somebody might be in the courtroom, but all right, this is Buzzerk v. Buzzerk case 16-9912-DM. Both parties are present. Mr. Buzzerk has Mr. Krupp present with him. This is Mr. Krupp's motion to compel discovery. There's a hearing coming up. He's asking for certain financial documents in her response. One of the things that Mr. Krupp is clearly asking for is in the last UCSO, there was $0 given to mother for income. And basically it was based on the fact that she was disabled. In her pleadings that she sent in, she says she is not disabled. Is that true? You are not disabled, ma'am?
Correct. I have no disability income and I'm a homemaker.
Well, raise your right hand, please. Do you solemnly swear or affirm testimony given this case to be the truth, whole truth, and nothing but the truth?
Yes,
All
I
right.
do.
Thank you. So you have no disabilities that prevent you from working?
I have health impairments, but I do not get anything from disability.
Well, what do you mean health
applied
impairments?
tonight.
What?
I have fusions throughout my back.
Okay, but you are able to work.
I'm not able to work.
Well, then you have to present that stuff to Mr. Krupp.
Would a letter with disability be sufficient?
You're
Or,
gonna
I'm
have,
sorry, not with, I have letters from my doctor that say I'm unable to work. I have a lot of documentation that follows that up. I have the recent letter in the last week from the appeals court that denied my disability request.
that denied your disability request?
Yes, I'm too young.
Mr. Krupp, I assume you want all of that?
Yes, Your Honor.
I need you to get that to him promptly.
How far does Mr. Krupp need it to go back?
Well, he needs it for now. I mean, it doesn't, we need to know that you are disabled. and
I
cannot
am not
work.
claiming disability, Your Honor.
Well,
If
then,
that was ever in there, it was a mistake. I am not claiming disability.
okay, then you will be imputed income.
Okay,
All right, it's just that simple.
that's
You either
fine.
are disabled or you will be imputed income. Your claim that you're a homemaker is fine, but you will be imputed as working outside of the home.
I don't know what you mean by imputed. I'm sorry.
It means we're gonna assign a certain amount of money that you make each week as a worker.
That's fine.
Yeah.
It probably should have been like that to begin with. I didn't enter the disability into it. My former attorney brought that up and I went with her recommendation.
I think we can take this up at trial too, Judge, the amounts.
You what?
I think she was working for Wolverine, so I think we can take up the issue of how much at the evidentiary.
Oh, that's, I mean, I'll have to find imputed income somewhere down the road.
Yeah.
I stopped working at Wolverine in 2018.
Was that your most recent employment?
No,
What was your most recent employment?
Spartan Nash. And I left there in May of 2022.
May of 20, do that. What was your income at that point? How much were you making?
I was making 70,000 a year at Spartan Nash.
All right.
I'd only been there 8 months. And due to back issues, I decided to be a homemaker.
Okay. Mr. Krupp, I think that's the information that you're really seeking.
Yes, that's right, Your
Um,
Honor. If you could just swear in that she's had no income since then.
I already swore her in,
Good.
and I have no reason to believe she's not telling the truth.
I think that's sufficient, Judge. She'll furnish disability stuff. We'll take up the income situation.
She's not claiming disability. She's giving us her most recent income. I believe she is honest with that. She has chosen to be a homemaker after that, is what she has said.
Yep.
And we'll deal with that. Although you realize the trial is basically it's not child support secondary to this. Okay, we got to find out what the parenting time is going to be so we can plug that in.
Correct, Judge. You're right.
And we'll see what happens with that. Anything else you are seeking? Because I'm not, Mr. Krupp, I'm not going to make her provide all correspondence between the two of them.
I think that disability is sufficient. In fact, she's admitted 70,000 a year is sufficient, and we'll see her at her trial on the 18th.
All right, ma'am, thank you very much. And we'll see you on the 18th. Good luck, everybody. Thank you. Mr. Jackson, are you there?
Yes, Your Honor, I am.
Did you serve, ma'am, did you serve the prosecutor's office with this? This is their case and we don't even have a judgment or anything entered on this.
I was told I filed it on the second floor of the 17th Circuit Court.
Yeah, and did you give notice to the prosecutor? I mean, this is I'll introduce the case. This is 24-5499DS Hill v. Jackson. This is a case that was filed by the Kent County Prosecutor's Office regarding child support. Mr. Jackson, I believe, has been defaulted on this, but no judgment or anything has been entered.
You're trying to say, like, if that's my son or not, you're saying?
No, I'm not saying that. It said that it is your son, an affidavit of parentage or something. The prosecutor's office is seeking a judgment of child support against you, sir.
Okay. And this is where we inquire about that, correct?
No. This is her asking for a temporary order that gives her physical and legal custody. And you get maybe some minimal parenting time and child support per the prosecutor's office, but the prosecutor isn't here.
Okay, and I'm supposed to agree or to disagree to this, you're saying?
I'm supposed to make a ruling. I mean, were you served with this motion?
Yeah, I have the paperwork. It looks like it's like her handwriting, I believe. I have the paperwork.
Where's your camera?
I have my camera off right now.
Why?
I just do, I guess.
All
So I
right.
know.
So, yeah, this is her request. Her request for a temporary order. But
Okay, I understand.
I'm gonna put you back in the waiting room for a minute because Miss Rummel is gonna be here later and I'm gonna ask her if she has any say in anything here. All right, so we'll get back to the two of you shortly.
Okay.
All right, thank you. They don't even have anything entered. And she's at least entitled to notice. We'll get back to you soon. All right, we're back on the record in 24-5499DS Hill versus Jackson. We were on the record a little earlier. nobody had notified the prosecutor's office, and this is a pending prosecutor's case, if you will. And at least needed to be notified of the request now for a temporary order. Miss Rummel is here from the Kent County Prosecutor's Office. You obviously didn't get notified of this. If you need to, we can do this 2 weeks from now or something, or Miss Rummel, what's your thoughts on this?
So it appears that the court signed the default judgment of support and uniform child support order on, Judge Hillary signed it on October 23rd. So we do have orders entered on this case.
And that order gives what? I mean, does
That
that
order gives initial custody to plaintiff, and parenting time is as parties agree. We also have a child support order that credits defendant for 0 overnights and calls for him to pay $340 in base support and $17 in ordinary medical for a total of $357 per month. We've got an uninsured medical split of 55% to plaintiff and 45% to defendant. And the effective date of the order is October 1st of 2024. So no objections were filed to the entry of the default. Parties are entitled to a review based on defendant's non-participation in the process of the child support, at least if they request it within the next 90 days. But any motions at this point, I think, are post-judgment, and if it's relating to custody or parenting time, I wouldn't be involved.
Okay, but the order does give mother initial physical custody.
Yep. Yes.
All right. All right, to the parties, you heard what Ms. Rummel said. This is now basically a post judgment request. Ma'am, what have you got to say? You do have initial physical custody.
Okay, that was basically the whole reason that I tried filing this, is because honestly, I don't feel it's in the best safety for him to be spending time with him alone. So that was the whole point
Well, I
of
can
this.
tell you that as a practical matter, if Mr. Jackson files a motion and wants to have time with the child, he's gonna get some time with the child. You're not gonna terminate his rights at this point, because that's basically what you would be doing, would be terminating his rights to ever see his child. And that isn't gonna happen at this point. So I don't know what you do have physical custody. And I don't, and it's parenting time is as agreed. So that, I mean, if he just came and took the child, you have physical custody, and you could demand that the child be returned and that you don't have an agreement on when the parenting time is. However, as a realistic view, if he asks for some parenting time, at some point, he's gonna start getting.
I'm coming down. I'm on my way down there once we get up off this phone to file whatever I need to. But I thought this was an order for support. The thing that I don't understand is all this stuff came effective as of October 1st. So I guess, why do we have a court date? I mean, it's been 30 days that any, thing has been ordered for, say,
I don't know what you're saying, but you haven't participated in anything up till now. You were defaulted. You didn't even answer.
What do you mean I didn't answer?
You didn't answer the complaint for child support and stuff like that. You didn't even respond to it. So
there was a no contact order put in place earlier this year.
So you when they file a complaint, you have to file an answer if you want to be part of it. And you didn't. You don't have to go see her for it or anything like that. You have to file it with the court.
You're talking about this paper that I have right here.
I don't know what paper you have right there.
This is the paper where it has my name, her name. It says motion of temporary relief. You're talking about this is what I needed to respond to?
Well, no, you needed to respond to the prosecutor's motion to begin with. the prosecutor's request for child support. You didn't respond. You haven't shown up. You haven't done anything for it. They entered a default against you because you didn't. That's what she just finished saying, was she entered a default and set child support that started October 1st because you were defaulted. Now, as part of that order, it gives mother initial custody. All
I
right.
understand. Yeah.
And so from there on, it's all up in the air. You don't have any, if you guys can't agree to it, you don't necessarily have any parenting time at this point.
No, I understand.
All right, so, and ma'am, your request, I mean, your request is you do have custody on a temporary basis. I can give you temporary physical and legal custody. As far as parenting time, it's as agreed, but that's already in the order that's out there. At some point, you're gonna have to figure out what is parenting time, because I'm telling you right now, you can't eliminate it. And are gonna have to figure something out. If he's never seen the child, he'll get to see the child. He's not gonna take the child for every other weekend right off the bat, but probably see the child somewhere at a place that the two of you can agree on for a little bit to get to know the child. Sir, have you ever had contact with the child?
Absolutely. My son knows who I am.
All right, then, you know, we'll break into some type of parenting time, whether it's, you know, a couple hours every third day or something, so that he can establish a bond with the child and work into that. You understand where that's gonna go, ma'am?
Yes, Your Honor.
So I don't know what, but unfortunately, you apparently can't talk to each other because Mr. Jackson has a PPO against him. Is that correct?
No, it's lifted now, but earlier in the year, you said I hadn't responded. We had a no contact order that was until the end of September.
All right, well.
But my next question to you, sir, is what do I need to do to come file so I could like?
Can't answer questions about stuff, sir. That's giving you legal advice, and I'm a neutral party. I can't tell you what to do and her to do. I'm just giving you my ideas of what reality is in this case. All right.
Right. Yeah. Appreciate it.
So at this point, ma'am, I can give you a temporary order, but it's just that. It's only a temporary order that you have custody. It's already in the other order. I'll give you custody and parenting time as agreed, unless we can figure. Do you want me to just send this to the friend of the court and have them evaluate it?
Yes, Your Honor.
You want that just to go to the friend of the court? Sir? They can look at, you want me to just send this to the friend of the court and have them look at what's appropriate? They'll look at custody, parenting time, child support. You know, they'll look at everything and come up with something.
I have to. So just a backstory, I have to get down there. So I moved recently and didn't get my mail. So I got all my mail and found out like my child support was already established, etc. And I know that I had missed those court dates, but I was planning on to get down there. I was wondering what
I'm asking you, do you want me to just refer this to the friend of the court?
I guess I don't, whatever is best for the situation. I don't understand the question.
They'll talk to each of you and try and figure out what's best as far as custody, parenting time, all that kind of stuff.
Yeah, that's fine then.
Is that what you want, ma'am?
Yes, Your Honor.
All right. Ma'am, you got a child there and stuff. I don't know. It's normally $150 from each person. I'll waive your fees and refer it to the friend of the court. All right.
Thank you. Go ahead.
All right, ma'am.
Okay, thank you.
Thank you both very much. Thank you, Ms. Rummel. Appreciate your appearance here.
No problem. Have a good weekend.
You too. Thank you. Both parties are present via Zoom. You can take your hat off while you're in court. This is a request from the plaintiff mother for child support. There was a child support order back in 2020, then a new one was entered in 2022 for zero on the consent of both parties because of 50-50, and also apparently wanted to opt out of the friend of the court. The parties agreed to 50-50. Now apparently they don't do 50-50. And so mother is asking for a child support order. Is that correct, ma'am?
Correct.
All right, sir. What's your
Your Honor, I didn't receive anything. The only thing I received was a text message yesterday letting me know about this court hearing. I have no idea what this is about. This is my first time hearing about this. Since our
ma'am,
last
did you send them a notice of this motion?
I sent it to 2727 Charles Gate in Wyoming.
I don't know whose address that is.
That's where his parents reside.
My parents reside at
I don't
29,
know his
29.
current address.
So I had sent, she knows my email since the last motion in
She's not
October.
supposed to serve your email. She's supposed to serve you at your address.
That's not my address, and my parents don't live at that address either.
That's the only address I know of.
Your Honor, I'm not going to say my parents' address, but that is not it. She's
I
asking
want
for
you to
a
say
couple
your
numbers.
parents' address. Have you kept your address current with the friend of the court?
Yes, I have. I believe I updated it back in July, or it was earlier this year.
All right, well, it appears that he doesn't have notice of this hearing, and if that's not his parents' address, then that's a useless. I mean, how do you know that's his parents' address?
His parents have lived there for years. I used to live at that house with his parents. His parents own that house.
Your Honor, I could send you my parents' home. She got the number messed up. That's what it is. She messed the two numbers up. She obviously doesn't remember where she used to live at.
All right, I'm not sure how we do this because we're on YouTube. I don't really want you to announce your address on YouTube, but I'm gonna give you, we're gonna adjourn it for 2 weeks. Well, sir, what is your parenting time with the kids right now?
It's supposed to be, we had this motion last month. She hasn't abided by it, but it was supposed to be every other day and every other weekend.
But it's not?
No, she hasn't been
That's
letting me
not-
see the children lately.
How long has it not been that?
It hasn't been like this since March 12th of this past year.
And that's,
Because of the
And
domestic.
And I believe that's what she's using this now, claiming that I don't see the children. She wants child support because she was been withholding the children from me.
do you have a
And the last-
PTO against them or something, ma'am?
No,
There was a no contact order between us during that time. It was lifted somewhat, but not fully. I can be around her, but there has to be minimum contact between us. And I've been trying to do that and go through a third party, trying to go through her third parties, and still haven't been able to get my children when the court says I
currently
should
have
be
one
able
of
to.
them.
What'd you say, ma'am?
So what basically happens is if he doesn't reach out for the kids, I don't reach out to him for them. That's not my responsibility. He knows obviously my phone number, where I live, and his kids have their own phones. So he could reach out to them asking them, hey, do you want to come over? You know, it's a
And I
simple.
do. And sometimes they tell me their mother doesn't allow them to come, or they.
Sir, let her finish.
So even on the weekends, you know, I tell the kids, hey, do you want to go to dad's or whatever? Sometimes my kids don't want to go. They don't really have a strong bond with their father. And so I'm not going to force them to go with him if they don't want to. But that's also on him to communicate with me and be like, hey, is there something I could do so I can get my kids more, you know? But there's not that communication either. So how am I, you know, like and obviously I'm a mom full-time. I have a full-time job. I need a break. So for him to sit here and say that I don't let him see the kids when he has full communication and access to me and my children, it's kind
Well, how
of.
many overnights does he get a year?
He gets maybe like, I don't remember. I mean, now it's obviously maybe like 80 nights a year, not even.
All right, sir, I'd set this for 2 weeks from now, but really all she's asking for is child support. And all I'm really gonna do is refer it to the friend of the court for a child support review and see what they come up with. So I don't see any reason to just simply adjourn it for 2 weeks, even though you say you didn't get notice, because you probably didn't. But it seems like a waste of time. You guys will come back 2 weeks from now, and I'd say I'm gonna send it to the friend of the court for child support review. You have any problem with that?
I mean, I would like to get some notice. She got my email. She said she knows how to get communicate with me, but she never told me about this motion.
Okay,
So, I
but
mean,
I'm just telling you what it is. She wants child support. And I'm not gonna set it here today. I'm gonna send it to the friend of the court. I'm not gonna set it. I'm gonna
okay,
send-
I mean, no, that's fine. Would that help me so I can be able to get my kids now? Because you just heard it. If the kids don't feel like coming, she wants something. I mean, I just want to be able to get my kids how I used to before I got a girlfriend. Ever since I got a girlfriend, I can't see my kids. I can't be around them anymore.
You object to me
Uh,
sending it to the friend of the court for their
I don't object. I know you will send it, sir.
Then we'll send it to the friend of the court for child support determination. Make sure when you get the stuff in the mail that you actually read and follow what they say. Do you understand, both of you?
Yes.
All right, good luck. Make sure the friend of the court has a good address for you, or else they're gonna send it to some place and you're not gonna get it, you're not gonna respond, and they're gonna make a decision based upon your non-response, okay? So make sure the friend
Okay.
knows your address. They'll send it, cooperate with them, and we'll see if we need to see you back in the future. Good luck. Thank you.
Thank you.
This is an objection to a friend of the court report and recommendation filed by the defendant in case number 24-3711-DP. Sir, it's your objection. You're saying you didn't do anything at their, because you were.
Mediation.
Is that what you're saying?
I'm sorry, Your Honor, I didn't hear the last part.
You're objecting because why? Because you didn't appear for the interview because you were busy?
I was at work and I couldn't get good enough service here at the hospital.
Did you inform them ahead of time?
No, Your Honor.
Why wouldn't you do that?
I don't know. It was I had so many appointments. So it was just all over the place.
So they were a lot more important than custody, parenting time type stuff?
Well, sending in the information, papers, I just got mixed up, Your Honor.
Well, I can't enter their report, ma'am, because he objects to it. I don't even know what the report says. So we'll set up an evidentiary hearing and you can show up in court and figure out what it's gonna be. I will review the friend of the court report and recommendation. I'm allowed to do that. And we'll see what it has to say. But I mean, I send it there. Did I waive the fees? I waived the fees for everybody. And then I find it really disheartening that it goes there for custody, physical, legal, parenting time, and child support, and you're too busy to do it when they set it up, and you don't even contact them ahead of time and tell them, hey, I'll be working at that time. Can we try and do something different? That's not exactly a valid excuse.
Yeah. I know, Your Honor. I just overlooked it. Like I said, my attention was not to miss it at all. Very important to me. Of course, like my child is everything, our child, and I just want to get this over with. And
I have to have an evidentiary hearing because he objects, ma'am.
Okay.
All right, I'll set it up. And everybody better figure out, because it will say on the front of the evidentiary hearing notice what you have to do and when you have to do it. You got to read that and do it. If you're going to have a custody trial, you're going to be going in blind unless you have an attorney. I'm warning both of you right now. Because this is a formal hearing in which there's going to be evidence that you got to know how to introduce it, when and where. It's going to be sworn testimony. It's not going to be hearsay and all this kind of stuff. So either you guys figure it out and enter an order, or we'll see you in court. But I'm not going to put up with, gee, I just didn't know what I was supposed to do. It's written right on the front of the notice.
Yes, Your Honor.
Okay.
Good luck, everybody. Thank you. You'll get notice of when the hearing is.
Okay, thank you.
Thank you. This is case 24-4720 DP, matter of Oaks v. Bacat. The defendant is present. It's his motion for custody. This matter was referred to the friend of the court just the other day, this month. Did you notify her of this motion?
Yes, sir, I did.
How?
I sent it to the address that she sent me. It's the Bellwood Drive address in Grand Rapids.
Well, how did you notify her?
Through mail.
When?
I sent it out a week and a half ago, maybe 2 weeks, something like that.
All right. So it appears that she has noticed. She has not appeared. However, you're again asking for 50-50. When was the last time you saw this child?
I haven't seen my child yet, Your Honor. I tried to set it up on the 18th of last month. I had to drop my stepchildren off at their dad's house, and I notified her that I couldn't make it to the place that she had set for me in a reasonable amount of time or in a safe manner, and she would not come off of the time frame that she wanted to for me to meet the child.
Well, the purpose of sending it to the friend of the court was so that the friend of the court could delve into what's going on in the case. It was referred there on the 7th of last month for physical, legal, parenting time. Also, I'm not going to change. I'm certainly not. I mean, you haven't seen the child at all. That would be a huge change in the established custodial environment to allow for something like 50-50. I'm going to leave it to the friend of the court to make their determination. You can file an objection to any report. Have they contacted you?
Yeah, there's a court date on the 13th, I believe.
Probably not a court date. It's probably a meeting with the friend of the court. Yeah, go to that, see what comes of it. I'm not gonna usurp their power at this point. Just gonna wait for the friend of the court, and we'll get to the bottom of it when they make a recommendation. And if you don't like the recommendation, then you can file an objection to it, and we'll end up in court. So
yes, sir.
Good luck. Thank you. We're adjourned. Glaspie versus Florian. This has been noticed up for today, but nobody's here from either side. Yeah. And this is an request from you to set aside an order of affiliation by the defendant.
This is his request to set aside an order of affiliation.
All right, he notified you and he's not here.
Yeah, and that has been the case with this particular defendant.
Yeah, I've seen, he's had 3 prior Zoom hearings set for 11/18, 12/2, 1/13, all of 22, 22, and 23. Never showed for him. I can't.
We've set multiple appointments for him to come into the office. He has had contact with us and he says he doesn't want to come in because he might have a bench warrant on another case. We have assured him that that's not our business. We just want the genetic testing. He won't come in and he continues to request genetic testing. So I would request that the motion be denied.
Well, yeah, since he hasn't shown up and he suffers no possibility of getting arrested being on Zoom from wherever he is, he just hasn't. And his idea for this is a late filing is because he says he believes another guy is the father. So what? I mean, I don't know how he knows that. He never took the blood test. He hasn't participated in anything. He's just filed this. This child's now close to 4 years old. I'm going to deny his motion at this point. Thank you.
Would you like me to do the order or will your office do that?
What? Can you do it really quick?
Yep.
I appreciate it. Sir, can you hear me?
Yes.
All right. You hadn't logged in. You're 55 minutes late. I just denied your request. What have you got to say?
I was out actually at work and just lost track of the time. I was working at I work at the airport and I was like moving the plane out and it kind of went a little slow.
All right, what do you got to say about your motion?
I was just trying to just pretty much try to get the blood, redo the blood. I mean, the blood test. See if I can try to do that if it was possible. That I still haven't really had no contact with the child, or haven't been trying to get a hold of the mother, to like just touch bases with her to see what was going on. And I
Why
just
haven't you participated in anything that we've done over the years? And what makes me think, I mean, your statement says, you know, you think another guy's the father.
Well, this is just when I had talked to her. This is what she said. It could have been, but I guess the guy lives out of town or something. But like I say, I've been trying to get a hold of her and like just talk to her, and I just haven't been able to get no type of contact with her. When I had a friend that we all used to work together, reached out to her, she just pretty much said that she has a boyfriend, so she couldn't talk to me. So that's what just
But what evidence do you have that somebody else is the father? I mean, my question really is, why haven't you participated in anything we've ever done?
Like far as what I know,
there were letters for genetic testing. You never got them. They were sent out on 8/17/22, 9/7/22. You never did it. There was Zoom hearings set on 11/18/22, 12/2/22, and 1/13/23. You never participated in those.
Well, I know at the time
one was entered. You just don't participate, but then like 2 years later, come in and say, "Hey, I don't think I'm the father."
I had a meeting before, and I was pretty much working at the give them a break. It was just like my job schedule went at back then at that time. So I know I did miss that last one where I got defaulted.
Missed all of
them. Yeah.
I mean, it's like you're trying to get a second bite of the apple way the heck after. You just don't participate. Miss Rummel, what's your position on this? Do you want to give him a blood test and see?
I don't particularly, and I do see that in defendant's motion, he states that he doesn't know where plaintiff or the child are. So I would wonder if they're even notified of today's hearing.
How'd you notify her of the hearing if you don't know where she is?
All I did was go to the downtown to the courthouse and ask some questions, and they told me to just fill out the paperwork, and then they just sent that paper out that
they don't send the paperwork to her.
Oh, see, I wasn't aware of that. I just was trying to.
I can't proceed with this because she doesn't even have notice.
Because I know even she hasn't showed up to no court dates as well.
But she has. How would she show up for something she doesn't even know is on for today?
No, I mean not as far as today. I didn't know that she would know. I just knew what the people told me to do the paperwork at the courthouse, and they set up a court date.
I set up a court date and you're responsible to notify her you didn't. So I'm not going to have this hearing today, and I guess I will deny the motion because she doesn't have notice. Thank you.
Yeah, I don't really know how I'm ever going to get a hold of her. She's not really trying to get a hold of me. I mean, she won't even, it's nothing. I had people that would try to get a hold of her.
I can't proceed no matter how much you talk on this. I can't do anything because, quite frankly, she doesn't have notice and you're responsible to get it to her. Good luck. Thank you. Menen Hall and Jordan. All right, what are we doing here? Because my understanding is that in May of last year, Judge Hillary dismissed this case, basically finding that the father was not the father.
Right. So our office, the prosecutor's office, initiated a support case. Then defendant filed an answer stating that he was not the child's father, and the court entered an order for genetic testing. And that testing established that defendant was not the biological father of the child. The case was then dismissed, but in order for our office to disestablish paternity and move on to a new defendant, new biological father, we have to have an open case with an order of non-paternity in it that would then be closed but not dismissed.
So you want me to open the case and close it?
Right. Open the case, enter an order disestablishing paternity, and close it.
Can't you? I mean, now that, because he's found to be not the father, can't you just open a new case against the mother and the new father?
We cannot because Mr. Jordan signed an affidavit of parentage. So he is the legal father until there's an order saying he's not.
But I thought that's what the judge said in his order. I mean, I don't know. This is all.
It's all very confusing, which is why this happens sometimes. If the case is dismissed, then all of the orders within that case are not recognized, essentially. It needs to be closed so that we can get a new referral through Office of Child Support on the correct father.
So you have the language that you want me to sign
Yes.
that will.
Yep, defendant's
Just so
paternity.
I just want to make sure that Mr. Jordan is not the father in any way, shape, or form.
He is not.
Because we know
No.
he's not. Okay.
We have genetic test results on file. I'd be happy to submit those to you if you would like before signing.
No, I trust you on that. I don't think you're gonna lie about it, especially when the judge already found that he is not, you know, that the paternity test show he is excluded as the father. You can send through whatever orders you need to open the case, close the case, and make him the non-father.
Yes, the only reason we found out about this is because the new biological father, we got a referral for that gentleman, but we had to reject it because technically Mr. Jordan is still the legal father on the books. So with the state of Michigan. So
I'll enter your order when you send them to me.
All right, I'm
spend a lot
sorry
of
for
time
the
trying to
mess.
figure them out because it seems like
Seems redundant, but
we want to
think
get
this
the
will fix it.
correct father paying the correct child support.
Right.
All right. Then your motion is granted. Okay, this is a case of Del Angel versus Del Angel 19-6545 DM. Both parties are present by Zoom. Can both of you hear me?
Yes.
All right, this is a motion filed by the father for child support. The only thing he says is that he pays insurance and a babysitter. And wants child support. What, I have no idea who has the children, when and where. Do you split custody or what?
I do have the child, and I got them since January 25, 2022.
Okay, and she sees the children when?
I had a legal situation.
Okay, I guess I don't
So
really.
the kids were removed from me
Okay.
2 years ago. So he
Well,
has them since then.
Okay, hold on. It sounds as if no child, you know, the only reason I'm really asking is this was referred to the friend of the court back in 2022 for child support and no one cooperated with it. Don't know why, but I guess I have nothing left to do but to refer it to the friend of the court for child support. They will take a look at it. They're going to contact both of you and request information from you regarding incomes and insurance and daycare and whatever, all right? If you don't cooperate, we're not gonna get anywhere.
I'm sorry, sir. I've been giving him 120 weekly,
Okay.
but I think for him it's not enough.
Well, I don't know if it is or not. You might be paying more than the child support will be. I have no idea, all right? The friend of the court will review everything. The friend of the court will get the information from you about your employment and whatnot, from him about his employment. We'll get everything together and we'll make a recommendation. If you don't agree with the recommendation, either of you, you have a certain number of days to object to it, all right? If you don't, it's gonna get entered, all right? So cooperate with the friend of the court, send them the appropriate information. If you don't like the recommendation, file it within the appropriate time or we're gonna end up entering. All right? Both
All right.
understand that?
Yes.
Yes.
Sir, we'll see what appropriate child support is. All right?
All right.
Good luck. Thank you.
Thank you.
Mr. Reyes has filed a motion regarding child support. He received a letter indicating that he had overpaid and should file this motion. Sir, how did you notify the plaintiff of this motion?
I was told to send copies. I sent copies before, and she never said if she received them or not. From the first time I filed the complaint, motion.
But did you send her this one also?
No, I forgot. I left it in my drawer.
Huh.
Yeah.
Oh.
Yeah, I left it downstairs. I got it in the envelope. I got it in the envelope and everything.
That doesn't help in giving her notice of this, you know that?
Yeah. Yeah, like I said, the first time I sent it, she never said if she received the first one.
Okay, but to the best of your knowledge, you have a valid address for her. I think it's in Brownsville, Texas. Is that correct?
Yeah, that's what I got from the paperwork from the courthouse.
From the friend of the court or the courthouse? Okay.
Yeah,
Sir, I mean, it's frustrating for me because I can't hear this because you admitted you haven't sent this to her and she doesn't have any opportunity to be heard. Your motion is straightforward. I think you came forward before and asked for this, but I had no idea how much I was supposed to order. Because I didn't
yes, sir.
Okay?
Yes, sir.
This time I have the letter from the friend of the court that says overpayment in the amount of $2,045.45. And I can't imagine why I wouldn't order that, but I need to have her notified of the hearing. So that in case she comes in and says, wait a minute, no, that's wrong. He forged that letter or whatever. I gotta have her have the opportunity to be heard. Okay.
Yes, sir.
And so
yeah,
it being downstairs, the letter doesn't help. So you need to give her notice of, then we're gonna adjourn this, so you don't have to refile it, just you gotta send her notice to be on Zoom, hopefully 2 weeks from now.
Okay, yes, sir.
But you need to send it to her, be honest about sending it to her so that she has a chance to be heard if she wants to. Okay?
Yes, sir.
So
I'll go do it. I'll go do it right now.
Okay, but I don't know that you can do it with the one that you got in the envelope because the date's gonna change.
Oh, that's right. All right.
So make sure you change the date on it. We'll set it for 2 weeks from now. So it'll be on the, 14th or something? 15th of November. Make sure you give her the information and let's see what happens then, okay?
Yes, sir.
Thank you.
Thank you.
See you 2 weeks from now.
Yes, sir.
We have a motion filed by the father regarding tax exemptions. In the judgment of divorce, it states that she gets one and he gets one. That was a consent judgment of divorce from last year. It's just about like 1 year old. He now says that he has all the overnights for the kids. And that the defendant pays nothing in child support, so he wants to amend the tax exemption to give it to him for both kids. Is that correct?
Yes, Your Honor.
And what's your response?
Yeah.
What?
Yeah, he has them overnight.
Well, my question is, do you object to him having the tax exemptions or not?
No,
You don't?
he can claim both of the boys.
All right. From now on?
Yes.
All right. Well, on stipulation of the parties, we will change that to indicate that he gets the tax exemption for both the children from starting with this year's filing. So in other words, the 24 filing on, okay?
Okay.
All right. Based on the agreement of both the parties, we will do a quick order saying that you are entitled to the tax exemption for both the kids. Thank you. This is a custody case that was filed by Mr. Williams regarding Walter and I can't remember the other child's name. I just remember one of them was the name of the father. But there are two kids, I believe, 8 and 4. Is that correct?
Yes.
And has filed a motion for temporary custody at this point. Was she ever served?
I've served it, but I got it. It got sent back, so I'm down here now at the courthouse right now, and they gonna find another way to try to serve her. But she's in Texas in an institution again. But I've been having the kids ever since the last temporary custody that we have done. I've been like,
I understand. I'm not really questioning anything, but I can't issue an order on a case if she doesn't even have notice that there's a case out there. Okay. If you haven't served her with the case that even starts this matter, I can't give you anything because she doesn't have any notice that the case is here.
okay.
All right. So after you serve her with this, the case itself that you have filed with the summons and the complaint, and you might have to do some work to do that, maybe even get alternate service or something. But I can't proceed with any type of temporary order unless and until she has noticed that there's even a case out there. So you got to serve her with the case itself. And at that same time, make sure that somebody serves her with a notice that of the temporary order request also.
Okay, so because I thought this was because they told me I did one for full custody and then I did one for temporary custody.
That's right, but that's within this. You're asking for temporary custody right now, but the case hasn't even been served to her to start it. Okay. So you can't get temporary in this case until you even get her notice that the case is started.
But see, this is what I'm trying to explain to the courts. Like, okay, so y'all gave me temporary custody once before. I had the kids since then. Like, she's never came back in the picture.
So why don't you have it from the prior case?
The temporary custody that they said is expired, but I've been having the kids ever since the first temporary custody that I had.
But yeah, you have filed a case, and in that case, you're asking for temporary custody. You have not served her with a case that starts this. She doesn't know anything about us here today. Okay, so I can't issue orders against her because I don't know that she even knows that there's a case going. You have to get the case going. So you have filed this. When you get her served, make sure you serve her with a notice that you're seeking temporary custody during this time also. But I can't do anything today because she doesn't even know there's a case pending.
I get what you're saying, but what I'm saying is she's never came. You ordered the temporary custody once before. She never been back.
Attached to another case that you had somewhere.
No, it was all right. Okay.
So, all right. Good luck. When she's served, we'll see you again. Thank you. This is the matter of Hiler versus Mendoza. It's case 22-3721-EM. This is both parties are present via Zoom. Ms. Smulders represents Mr. Hiler. Ms. Coletti represents Ms. Mendoza. This is a motion filed for parenting time from Ms. Mendoza through Ms. Coletti. We were here not too long ago. A major complaint that Ms. Coletti voiced for her client was that he gets to pick the kids up from school and that's his parenting time after school for a couple of hours. And the last time we were here, the major complaint was he doesn't always do it, and then she has to jump in and do it, misses work and all that kind of stuff. I didn't change anything, but said if he continues to do that, maybe you want to come back. I now have a thing that he missed one of the days, I can't remember the date, called her, and Ms. Smulders says, well, they agreed on an option on how to do this. She said she had to miss work to pick up the kids again. Ms. Coletti, does that pretty much state what you have?
Yes,
Yeah, and on October 11th, she texted him at, I believe, 3:58 and said, "Are you picking up the child?" And he wrote, and he said, "No, I couldn't get her." So this, he texted it on the 12th, but this wasn't prearranged. And since October 11th, he also missed October 17th for a flat tire. October 18th, his rim was not fixed. October 24th, had an axle blown, and October 25th, his truck was in the shop. So unfortunately, he's not been able to pick up the children, and we just cannot rely on him. So Ms. Mendoza is able to change her schedule, but she can't keep changing it.
Okay, but let me ask you this, all right? What are you seeking?
I'm seeking to end the midweek parenting time so Ms. Mendoza can pick up the children from school and have them.
Doesn't she have to change her work schedule to do that no matter what?
She's arranged with her work. They've been understanding so far, but if this is granted, then she will change her schedule and then she won't have to leave work.
So she will permanently change her schedule?
Correct.
All right, Ms. Smulders, I'm inclined to do this, but go ahead.
I understand, Your Honor. So I was not aware of the other dates that Ms. Coletti had just indicated. All I was aware of was the October 11th date. And I do have text messages from my client where the parties did discuss it the day before. And so I have issue with the part of the motion where Ms. Coletti indicates that my client caused her client to miss work and have to pick up the kids. And I just feel like that was a bit misleading in terms of the actual conversation that, Ms. Coletti's client had indicated it was okay and that she would on that day. I shouldn't say kids. One of the children had that day off of school anyway, so I believe she was in Ms. Mendoza's care already. And so the other child had to be picked up from school. So as it relates to their motion, as it relates to October 11th, that is the reasoning for that. I am not prepared for the other dates that were listed, and so I'd have to inquire of my client regarding those. But I know that he did have some employment opportunities, which he has declined because it would have caused him to interfere with that 4 to 8 parenting time.
Well, but it sounds like, see, the problem is, even if he communicates with her, it defaults to her to pick up the child no matter what. I mean, he says, "I can't do it, so what should we do?" All right. I don't even understand why that is an option. It's his time. And you know what? If it was only one time, I don't know why I didn't hire an Uber or something to go do it. All right, go pick up the kid. But this is a recurring problem. And it doesn't fall back on Miss Mendoza to be the fallback on everything. It does, just because, quite frankly, there's nobody else to do it. And she's providing that time, and he's providing it when his truck works, or when he doesn't have a flat tire, or when he has this or whatever, and that's just not appropriate. Your client wants to say something, I'm disinclined, but if it's very short, he can say something if you want him to.
I would advise him not to.
Why don't you do this? Why don't you two go in a breakout room for just 2 minutes? No more than 2 minutes.
Yep. Okay.
She's gonna go in a breakout room with you to discuss this for a minute. All right, Ms. Mulders.
Yeah, so I was explained that when he was driving, apparently something had hit his car. He maintains that it was an accident. I understand the court's position, and I did explain to my client kind of the history prior to my involvement, and that's where the court is probably coming from, and as well as Ms. Coletti and her client. What I'm going to try to ask in the alternative, if the court is going to take away his Monday through Thursday 4 to 8, if there's any, I guess, convenient way to maybe reduce the daily parenting time into maybe an extended few hours on the weekend, maybe picking up the girls earlier, or getting maybe one longer weekday parenting time.
When does he get weekend parenting time?
Friday through, well, I have to
Friday
check.
through Sunday every other week? Is that standard, like Friday through Sunday every other week?
That's correct, right, Greg? Friday through Sunday?
Yeah, that's correct. That's all I get them. It was Thursday, Friday, Saturday, and Sunday. She's letting me, but then she wants to take away the Thursday because it was gotten in the court order. But I did that since March.
All right, Ms. Coletti, is there any response? My thought is that he can, I'm gonna take away the Monday through Thursday. He can have every Wednesday from 5 o'clock till 8 o'clock to see the kids, midweek.
So he'll do transportation both ways then? He'll pick them up from, they usually meet, I believe, at a police station?
Yeah, how far do they, yeah, they can meet at the police station. Is that a real far drive for either of them? I don't know where these people live, so.
I don't, that's what they've been doing, so.
It is what they've been doing. My understanding is it's about double the time for my client versus Ms. Coletti's client.
I do want to say one thing. I want to interrupt because my truck is 100% fixed, up and going. It was a malfunction. The hub bearing and the axle went out. A piece of metal shredded the tire. All I want to do is see my kids.
You've taken my patience, and I'm going to give you every Wednesday from 5 till 8. You can meet at the normal spot where you exchange, and every other weekend as far as the other time. I'm going to eliminate that at this point. I think, are we scheduled for some?
We do have a friend of the court investigation. I think that's coming up here this month. And then I think we're scheduled for an evidentiary the earlier part of next year, depending on that.
We'll still go through that. Ms. Coletti, you're free to say something. I think I'm just going to give him a midweek from 5 till 8. Any objection to that?
Well, I disagree with it, Your Honor, but at least she will know that she's got to pick up the kids from school.
Yeah, she's gonna have the kids all the time, and from one night a week, that's pretty, as you're well aware, that's pretty standard parenting time, and I'm just gonna go back to standard parenting time.
All right, thank you, Your Honor.
If you will draft the order, I'd appreciate it.
Thank you, I will do that.
Thank you, everyone. Take care. Good luck.
Thank you.
You were divorced in 2022, right?
Yes.
Why am I doing the revocation of paternity on a 1-year-old child?
Because I try to get the certificate birth and the social, and they told me because I don't know how many days after I divorce, so I can do it. I need like the court later that I can do it. It's not have sense for me.
When did you conceive the child?
In 2022, when I started the divorce, I know I was pregnant. When they give me the divorce, I don't really know that I was pregnant, you know?
Okay, but you might have been pregnant when you were divorced in May?
Yes, I was pregnant in February.
All right. Then why don't I just order a DNA test? Can you have Mr. Lopez participate in a DNA test?
It's better if I can do it with the correct father because I don't really speak with Lopez.
Okay, but you do know who the father is?
Yes, of course.
Sorry, I hear these and some people have no idea. So, sorry. Why don't we'll send out an order for a DNA test.
Okay, one for Tiago and one for Valerie, right?
And you can have the child, Valerie, DNA tested. And if you bring in a DNA test from the father and the child that shows he's the father, I'll grant your motion at that point.
Okay, perfect.
Okay, I just need to know that Mr. Lopez is not the father.
Okay, so I need to do the ADN test and then I need to go back to the court.
And then renotice this motion to me again.
Okay.
With the test results, okay?
Okay.
We'll send out an order. I can't order him probably to do it because he's not a party of the case. All right. All right, well, the order is going to say it'll be for Mr. Lopez and the child, okay? Now, what is the father's name?
The father from Valerie,
I'm sorry,
for Valerie or for Tiago?
for Valerie.
For Valerie is Cruz Olivares Macegosa.
Oh, goodness gracious.
It's with Valerie.
Email my clerk
Okay,
the name that you want on it, all right?
okay,
Because then I can issue an order you can take to him to get a DNA test.
okay. But it's like two different fathers. I have one for Valerie and one for Tiago.
Well, Tiago, the father of that one has already been found to be Mr. Lopez.
No, it's not. He's not the father.
But that was in the judgment of divorce.
Yes, but he's not the real father.
Well, he is in the judgment.
Okay, but I opened two cases, one for Valerie and one for Tiago.
There's no valid reason for me to open a case for Tiago, because Tiago is 5 years old. He was born during the marriage. He was listed in the judgment of divorce as you each got 50-50. Parenting time, that's not appropriate for him.
Okay, we can do like ADN test too, because he's not the real father.
Well, he is the real father. He's the legal father.
Okay, but the real father want to put his name, and I don't speak with him, and then I need to take the passport. I need to renew the passport.
I mean, you did the divorce.
I know, but you know it
and
was.
you listed him as in there and everything. I'm not going to redo that. I'm going to do the Valerie because she wasn't. You didn't even know you were pregnant, but you were, and so it was a child born out of wedlock. So I'm only going to do her. And if you will email my clerk the real father's name, we'll put it in the order and you can get a DNA test, but I'm not doing it for Tiago. That's a totally different world. And you don't have any reason. Tiago's 5 years old.
Yes,
or more than that.
I need to renew the passport, and I can do it because I don't speak with Lopez, and he's not the father. So he don't have document.
That's a problem that you're going to have. Maybe you have to come to the court and ask for permission to get a passport because you can't get in touch with him. But he is considered the father. And you even wrote in here you had 50-50 parenting time.
He's not here. He don't speak with him. I live in Michigan. He lives in New Jersey.
He's the father. You listed him in your judgment.
I understand, but I don't really.
It's too late.
It's too late.
It's too late for that one. Valerie is not. Valerie is not. So you can send us the name and we'll put it in the order and can probably find that Valerie is not that we can deal with Valerie. So if you can email my clerk.
Okay.
Do you still have my clerk's email?
Oh yeah, you just send it to the chat.
Okay.
If she can copy that.
Yeah. You just sent it to you. So if you can copy that down.
Oh, but I can right here. What do you need from me? The name? I know I can.
Name of the father of Valerie.
Valerie. Okay. Okay.
I've got his name. It's Cruz Olivares.
Yes.
Macegosa.
Yes.
All right. I've got it. We'll put it in the order. You'll get it. Follow the directions, get it done. And then renotice this. All right.
Okay.
Thank you. Good luck.
Thank you.
The plaintiff has admitted repeatedly that she is denying my client parenting time. We have filed complaint after complaint after complaint for parenting time.
Just making sure that mom does attempt to facilitate that parenting time. I know she doesn't want to go to jail, court doesn't want to have her go to jail, but I will tell you, when parents have not attempted to facilitate that, I have put parents in jail for that. So just so you know.